The Attorney General has entered a nolle prosequi in the high-profile case involving former Finance Minister Dr. Duffuor and 7 others who were facing charges related to the collapse of UNIBAnk. Now, that decision, announced by the Deputy Attorney General, Dr. Justice Remsai, effectively discontinues the criminal proceedings that is against the accused. A move the AG's office attributes the significant recovery of state funds. We want to delve into this matter right now on the AM show, and Samuel Kojo Brace and I are here to steer the conversations. And we want to engage Justice Abdullahi. He joins us via Zoom for the diverse perspectives on this matter. Justice Abdullahi is a lawyer. And Justice, thank you so much for joining us this morning. Good morning.
Good morning. Thank you for having me.
Great. Kojo, over to you.
Justice, I'm sure you follow this particular matter about the fact that the AG says, well, because the state has been able to recover 60% of the funds, then the decision is we want to let them go. From the legal point of view, what do you make of this particular matter, and what does it serve for future happenings in such circumstances?
Thank you so much. So, as you rightly pointed out, the AG has entered nolle prosequi. The normal narrative will be that if you want to play mischief, you'd probably put it this way, that once there is 60% recovery of the amount lost of the state or alleged to have been mismanaged, it serves to encourage other future possible tests, cases to perpetuate itself, simply because the people within that space would find it more motivational and beneficial to steal so much, with the hope that they'll make away with about 40% of the amount allegedly inflicted on them as having been stolen. These are normal narratives that you may have from people who want to play mischief. But being close to this particular case, you would discover that the amount that is, was alleged to have been mismanaged was quite difficult to be deciphered by both sides. And so you would discover that both sides were in complete disagreement as to the exact figures that were in contention. Now, that is just one aspect of it. The second angle to this...
But why were they in disagreement when the funds came from the Bank of Ghana, which, of course, would have records?
Yes, but the accusation from the state is not necessarily the amount that the Bank of Ghana gave these banks. It stems from the amount that is alleged to have been mismanaged. And so the state is not really accusing these persons for having stolen money for their private benefit or anything. The state is accusing these persons for a number of things, but the essential part of it is the fact that monies have been mismanaged, not that monies have been stolen. And so it is not an issue where an individual has the benefit of these monies in his private coffers, where you simply just trace and recover it. These are monies that have been lost for obvious managerial perspective, either because you gave somebody a loan that you did not have adequate measures to protect the loan, secure the loan, or you undertook a particular project that were not properly accounted for. So these are completely different from your regular, everyday cases of stealing, where an individual has deliberately taken steps to enrich himself.
I asked the question because when the banking sector cleanup came, there were reports that were released by the Bank of Ghana into each company's actions upon which they've taken that decision. Some have to do with in borrowing, when sister companies of the same bank were borrowing without due process, when some loans were given to people without due process, and all of that led to a high non-performing loans in the companies. That's why the Bank of Ghana took that decision. So I'm saying, if the Bank of Ghana, or I'm asking, if the Bank of Ghana gave us that report, which meant that they had the records of how these monies were utilized, why are they now saying that they kind of disagree in terms of how much exactly was involved.
So it is not, first off, that narrative was a narrative that was painted across board. But individually, each party, or each given bank had a particular role that it played in this scheme of mismanagement.
Yes.
So if you go into the individuals, you discover that everybody's issue was relatively different from the other.
Exactly, yes. Yeah. That's basically what I was saying.
Good. So if you go specifically to the issues of Duffuor, they were relatively different from the issues involving
ACN.
Sorry,
ACN. And same with Royal Bank. Different issues.
However, the narrative you just painted which is what the narrative we had in the past. It made it look like everybody else had done the same thing throughout the period. But that was not the issue.
No. What I painted was specifically, I don't want to quote, but I'm paraphrasing. In terms of UNIBAnk, there were sister companies, according to a report that we read, sister companies had borrowed loans that didn't follow due process. They had advanced loans to individuals and companies that didn't follow due process, with UNIBAnk specifically. That's why I want to understand, how can the two entities, BOG or government, and UNIBAnk say we disagree on the exact amount when Bank of Ghana itself released that report in 2017 that we all read?
Absolutely. I do completely share in your sentiment. However, as I was saying, it gets to a point where you have to take that firm decision to move forward. We were confronted with this issue of making a determination as to whether to pursue these matters to its logical conclusion, with the possibility, let's all remember this, the fact that you're prosecuting a person is not in any way saying that you necessarily would win. And the interest of the state at this point is our money that has been lost as a result of these mismanagement that have been perpetrated by the banks involved. And so a decision had to be made. And that decision was a firm decision as to how to recover these monies. And if you remember, this government's position right from the day it was sworn in has been one thing, that all looted funds must be recovered. I think this is what has been guiding the AG. If you discover the AG's nomenclature since the Attorney General was sworn in, together with his deputy, their entire posture has been to recover all lost proceeds. From all the cases, from Duffuor's cases to all the other cases that, high-profile cases that we've all been observing, at least within the media space. The narrative has been one, and that is to recover looted funds.
I seem to, sorry, Justice Abdullahi, I want to interject here. For me, I think that we shouldn't discuss this and give the impression that they have dropped all charges now. The nolly prosecuted, to the best of my understanding, means that they've discontinued now, but it means the case can be reopened. So what is the significance here? Because this happened during the NPP's administration, and they were the ones who said that these people, the accused persons had plunged the country into some financial loss, etc. They said they hadn't done any wrongdoing. Yesterday, I just want to quote here, he said he said that this does not in any way imply an absence of wrongdoing, nor a vindication of any conduct. It is a pragmatic step in line with the overarching national interest of recovering state resources. So where do we see the end of this case? Because at any point, successive administrations or governments could open this case again. So are we just waiting to take all the money and then let them go? Or how do we bring some finality? Because you said not necessarily to win, I just want to pick your thoughts on that.
Yes, it is accurate to put it that way, that when you enter a nolle prosequi, it is not a finality to an issue before a court of competent jurisdiction. And the reason is very simple, because the matters involved have not been decided on its merit. And if a case has not been decided on its merit, what it means is that at any given time, should any new development occasion a reopening of the case, the courts are allowed to go back into the matter. And if any wrongdoing is found and the person is convicted, that will be the end of the matter. Until then, at this point, everybody is sitting on a tenterhook because you are not completely cleared and neither are you completely free. So yes, even within the same government, we wake up tomorrow and the Attorney General discovers something new that is completely outside of what it has been privy to. The Attorney General can always go back, effect an arrest, put the matters before court again, and notwithstanding the agreement that had been reached, will still be able to proceed with the prosecution of the issues. So, yes, we are at this point. Now, the second part is that, not with regards to the nulli prosequi, the second part of the amount involved is that my understanding from my communications with the AG's office is that it is not abandoning all debts, that is, all debts owed the bank as we speak. And there are about 1.2 billion Ghana cedis that are still outstanding. And these monies are likely to be recovered with a new level of energy. Because over the years, we've discovered, we've seen that the officers in charge of these banks have not been doing what they need to do for us to get these monies back. And so everybody is really jittery because those who are owed the banks are not getting their money. Those that owe the banks who are not paying. And there's nothing that seems to be done about it. And we are talking about close to 1.2 billion, if not more. If you add that to the 600 million, we are heading to close to 2 billion Ghana cedis, which is such a significant sum that can change the entire narrative of this whole story.
You've been getting some briefing from the AG's office, so I want this clarification. Now, we're told that the 60% is out of 5.7 billion cedis, right?
Well, no, the 60%. I do not know. I do not have the exact figures out of which that is coming from.
Okay, all right. But again, if you read the statement, it says that the accused persons in the Republic versus Kwabena Duffuor and 7 others case have met this recovery threshold. What do we have the right do we have the right to demand the evidence to indeed be satisfied that, well, they've met it indeed? And so that is right for the government to, a decision for the government to take.
That is the legitimate question all of us as citizens who are interested in participating in our democracy should actually be doing. We should ask questions, we should seek clarity, we should seek evidence of these informations. And I think it is not out of place to demand that the AG, for instance, furnishes us with the 60% payment. But I'm aware that the 60% came from audited properties of the persons involved and not necessarily cash. And so to that extent, I think we can easily verify these facts and get accurate information on them.
But if audited properties, what does it mean? That they will be sold for the proceeds to get to the state, or what exactly?
The state has a lot of uses for property. It could sell them. It could also make good use of it. We all are aware of the state lacking offices and other things, and I'm sure these are high-profile property worth this quantum clearly can do a lot of things for the state, either by way of sales or by way of occupation.
So do I get the understanding that the state has taken over these facilities?
To the extent that the agreement has been reached between the parties and the assessment of the property, their quality, their value have been done, I can say with all level of certainty that yes, the state is in the process of taking over legitimately and through the appropriate legal means anytime soon.
With all these, there's still some things that are unclear about exactly what went into this 60% and meeting this threshold in terms of the recovery. And so for those who argue, say that these people, Dr. Kwabena Duffuor and the others, have found favor in the eyes of the AG. Political favor, I don't know for sure. How would you counter that argument? Or how would you explain to them that this is strictly a legal process that has just panned out this way? Because you and I do not know exactly what went into that 60%. You're saying that some of these assets, we cannot confirm on air right now, but we are being told that they've met a certain threshold in terms of recovering the monies. Does it not smell like politics at play here? Partisan politics at play here?
So it is easy for mischief makers to play mischief with facts. But we witnessed the passage of the Plea Bargaining Act under the last regime. Now, that was clearly a legal document, an enactment that was put in place to serve as a roadmap in the event of these things happening. And a lot of discretion is given the prosecution's office, that is the Attorney General's office, to make determination of what they believe is right and appropriate for the state. They have that discretion solely imposed on them or granted them by the law. I mean, and so the amount of 60% could have been by the discretion of the Attorney General or any of the officers who is put in charge of this matter. So could it be as a result of negotiation? It is. Remember, plea bargaining is a negotiation. So if you have a stronger bargaining power, depending on the circumstances, it could have been 70%, it could have been 80%, it could have been 100% recovery. But this is what was arrived at. And the amount arrived at, I'm sure, took into consideration all the circumstances, and all stakeholders played a role. I'm aware the BOG's office, the Ministry of Finance office, all of them played a role in arriving at this figure. And so it is not something that you could easily discount as having been influenced by something other than the interest of the state.
What do you say to those who say this could open the way, or I mean, like people put it, the Pandora's box for people to engage in siphoning the state's money and then entering into an agreement with the state to say, okay, I'll pay 60% of it. After 8, after 10 years, someone was explaining earlier that if you do 15% per annum over the 8 years, that money will jump to a very huge amount. How do you respond to
this? This is what I was explaining earlier. That if you look at the specific circumstances of this case, it is different from your regular stealing cases. If it was a stealing case, I can assure you that knowing the AG and his deputy, there is no way they would have agreed to anything less than 100%. Absolutely no way. And there's no way they would have even settled on the 100% and simply asked the perpetrators to walk. Knowing the AG from the little that I know about him and his deputy. As for the deputy, I can say with all level of certainty that we come a long way. We come a long way. So I know him in and out. And this is a
conviction you have based on your knowledge of a person, not based on the facts of.
So let me finish with this. Okay. So my point is this. So because this is not one of your regular stealing cases, it is difficult to say that the monies have been stolen by these persons involved. And so on the basis of that, you are recovering the full amount. As we all rightly pointed out earlier, we all agree that these monies were lost on us through bad managerial decisions that were made by the officers involved in these companies. And so necessarily, you can confirm that the monies did not go to their private pockets. It is a different case if these monies were stolen. But these monies went to people who probably did not deserve it. Those people, those third parties, you cannot just go around taking these monies from them. If I came for a legitimate loan,
including their own companies.
If I came from a legitimate loan, right? I came for a legitimate loan as a private citizen. And your decisions led to my inability to pay the money. It is difficult for anyone to pin that on you and say that you're stealing that money, necessarily. It is not the same. But yes, you took bad decisions. I took the money. I didn't pay. It doesn't mean you had the money with you. And so to say that that person should pay all that money, legally, you may be right to do that. But reasonably, I think if you're exercising a discretion, you should be able to exercise it, taking all these factors into consideration and say that, okay, well, because you caused it, pay so much of it, and then we can let go of the rest. But if you had stolen it, I could easily say that, well, you stole it, you have even made profit out of it, you use it for your private benefit, and so you are paying 150%. That is a reasonable angle to take this argument from.
Are you saying that the actions of Well, now, should I say they acquitted, but then the defendants, would you say that there was no wrongdoing at all? Following the analogy and the argument you're making, there was no wrongdoing. We were just victims of circumstance.
That would never be my argument.
Okay.
In fact, I was the one who even called for their prosecution in the first place.
Okay, so there was some wrongdoing.
So there were definitely some wrongdoing, which is why they are paying this amount of money. This is a lot, in fact, a huge penalty inflicted on them.
Okay, now we can back the wrongdoing with facts. But your conviction in terms of how satisfied you are with the outcome of this, I mean, the fallout from court, is that you know the AG as a person, and I'm uncomfortable with that. You're not backing it with the fact that perhaps this is what the law said and that is what they had done. You're saying that because of your knowledge of this person, they couldn't have done anything, you know, in contrary to what the provision of the law dictates.
Actually, that is not what I said. I said that.
You said you know the AG from your knowledge.
No, I'm not talking about that part of it. I'm saying that they followed the Plea Bargaining Act, did several consultations with the other stakeholders, and they all came to that conclusion that the 60% was a fair deal. This is what I said. So I wasn't relying on my personal knowledge of them. I was saying that on the basis of that, if the people had stolen the money, there's no way, knowing them, the AG and his deputy, they would have allowed them to go away with 60%. This is, so put it into perspective, and I mean, so that we don't take the angle out of it. I mean, the context really matters.
Okay.
Now, I want to bring up, something the Daily Guide reported here. It says, the fact sheet presented at the beginning of the trial had indicated that UNIBAnk went into official administration on March 20, 2018, and was placed in receivership on August 1, 2018. It said KPMG, the official administrator in course of its duties, discovered that about 5.7 billion cedis had become due from shareholders of UNIBAnk as of March 2018, but no security nor proper credit arrangement were made for the payment of the amount, which remains unpaid. This one, the people they mention here are shareholders of the company. Can we still say that this wasn't deliberate, or people who had gotten access to the state's resources and they deliberately shared it among themselves? Help me understand what this means.
So remember, this was my position, that these decisions were faulty decisions. These decisions ought not to have happened. This is what I said a minute ago by giving you the example of how some of the decisions were made and why these persons are required to pay this huge sums of money as penalties. Deliberate or otherwise is something that you could only prove in court. It's not something that you can make a decision of through fiction or an imaginative angle. You have to prove this, that they were deliberate in doing that. However, the fact that the person is being prosecuted clearly tells you that the decisions were considered willful as far as the state is concerned. And if it was willful, then you have to suffer the penalty thereof.
Okay.
And the penalty, if you are able to pay, we should let you go, because that is the object of the whole thing, that the state must recover.
That is the basis of the Plea Bargaining Act. And the Plea Bargaining Act was not enacted by this government.
Okay.
You may question the discretion as exercised. You may feel uncomfortable with some of the bargainings that are reached. They are legitimate questions. I cannot fault you on that. But a decision has to be made.
Yeah.
Okay.
All right. Well, thank you so much.
But just before we let you go, another legal issue.
Yeah, go ahead.
Absolutely.
I mean, and you're a constitutional lawyer, so you do get as well. You help us understand what the law really says. The decision by the Supreme Court to quash that 5-year arrest warrant, people say the young man should have been picked up first to at least in honor of that warrant that was issued 5 years ago, before the Supreme Court would take that decision it took. What's your thinking on that?
Right. When a warrant is issued, there are a lot of processes that go into putting it into effect.
Okay.
That process is largely determined by the court itself, and in fact, there are legal processes. So the court has a role to play. Whoever brought about that decision has a lot of role to play. if you do not invoke those processes, the police cannot of themselves go around arresting people simply because they have heard in the news that a warrant has been issued for their arrest. So you need to, once a warrant has been issued by a court, you need to follow the processes before you can arrest a person. If you don't do that, that person will be working as a free man.
Okay, all right then. So you don't agree with people who say there was failure in due process on this decision by the Supreme Court?
I wouldn't call it agreement or disagreement, but I would first question what happened after the warrant was issued, the steps that were taken. If no step was taken, that warrant is as ineffective as the paper it was written on. But if you take steps to effect the warrant and you face bottlenecks, that is where we can then discuss these issues about whether or not there were merit or otherwise.
All right, grateful to you for joining. But just before I let you go, I mean, once we've had you, let's try and explore all of these issues. Another issue has to do with the National Cathedral, and I'd love to pick your thought on it. Now, this is a statement by the Ghana Catholic Bishops' Conference on, that's a different matter there.
I think this is on the suspension of
exactly.
Chief Justice.
On the Chief Justice,
yes,
the Catholic Bishops. Okay, anyway, interesting. They says, we the Catholic Bishops have followed recent development in our beloved nation with profound concern. Our spiritual leaders through democracy. And anyway, let me check this one here because there's some vital point here we need to ask you on. It says, in the light of these grave concerns, we urge all stakeholders to act with utmost conscientiousness, safeguarding both the inviolable rule of law and the dignity of the judiciary. The recent National Day of Prayer and Thanksgiving convened by His Excellency the President provided a welcome moment for spiritual and civic reflection. May this now inspire a deeper, sustained national commitment to unity, reconciliation, and lasting peace. I mean, when it comes to the removal of this the CJ, the Catholic Bishops' Conference are asking for due process to prevail. And I think this is something you will agree with them. What's your thought on this?
Indeed, I fully agree with them that at every point in time, due process must always prevail, at every point in time. But calling for due process to prevail would also, at this point, mean that they think or believe that there are some breaches of due process. If that is the thinking, then I beg to differ on that. I have, if you remember, right from the day these petitions were sent to the President's office to this point, I have been part of citizens participating in the entire discussions on this issue. And no single provision of the procedural rules have been impugned to have been wrongly invoked.
Okay.
Not by the CJ, not by even members of the MPP who were initially the spokespersons or pretending to be the spokespersons of the CJ, and other people who felt strongly that the CJ was not being treated fairly. Nobody till date has been able to point out what has been done wrong up to this point. And so on the basis of that, my position is that if a person believes that something has been done wrong, either against the Constitution or against any of the procedural rules that we have in this country, I think the right thing to do when you're calling for due process to prevail is to point out one that you think has been infringed on. Then we can have a constructive discussions and see how best we can all put our voices together and impress upon the state to act right. Until then, I have pointed out and I have called for this debate that whoever, from the bar association to the last cleaner in the streets of Ghana, that thinks that any provision in any of our procedures or constitution has been breached should point it out so we can have a debate on this. Once we have a debate and it turns out that indeed there is a breach, I think it to be appropriate for us to then insist that the president acts right.
Okay.
Until then, I think we have to leave this matter to rest. Because
now, if you listen closely to what they wrote, they say, quote, a healthy, functioning democracy equally demands an independent, credible judiciary free from political interference. Justice is the indispensable cornerstone of national cohesion. Without it, grievances fester and violence finds fertile ground. It is in this critical regard that we view the current tensions arising from the suspension of the Chief Justice. While acknowledging the necessity of due process, we caution strenuously against any action, perceived or actual, that could compromise the independence or impartiality of the judiciary. The removal of a sitting Chief Justice is a matter of profound national significance. The process must be scrupulously guided by constitutional principles, absolute procedural fairness, and a clear respect for the doctrine of the separation of powers. Any precedent that appears to place the judiciary at the mercy of the executive risks irreparable eroding public trust in the very institution citizens rely upon for justice. Aren't they cautioning that if we could, maybe we take steps a little backward in this?
Well, I am not close with authority to interpret what they say, but the meaning I glean from what they are saying is a legitimate one, which I completely agree with. I completely agree with everything they've said generally. But as I indicated earlier, is it in any way insinuating that some wrongdoing has been occasioned simply by the suspension of the CJ? That answer must be provided. Once we get a firm response on that question, then we can have some form of impartial discussions and then see how best we can all move forward on this.
When you hear the subtle undertones about the desire for the removal of the EC chairperson, the Catholic archbishops are saying that if you set a precedent that puts the judiciary at the mercy of the politician, it risks some, eroding of public trust. If you look at what is happening to the EC, won't we have the same if the CJ ends up being removed? And that's the cry of the bishops.
Yes. So my answer to that is a very simple one. Very simple. Are we saying that we should allow a rotten constitutional body or officers of constitutional bodies to persist in office simply because we need to protect the sanctity of that office when there are evidence of wrongdoings occasioned by them? Is that the argument? I do not think that's what they are saying.
Okay.
But if that's not what they are saying, and there's a legitimate petition for the misconduct of a person occupying that office, do we let go of that just to protect the independence of that institution? Okay. I do not think that is also an argument that any of these persons, stakeholders, are making.
Okay.
Now, if these are not the arguments, then I think that we are just throwing caution into the wind, because really, until you are able to point out that something else has been done wrongly, if a person does something, even to the office of the president, if the president is seen to have misconducted himself against the Constitution, would we say that simply because we need a cohesive country, a robust nation, a united front, we should allow the president to remain in office when he has done wrong that occasions his removal? Okay. That can never be an argument to be made by any constitutional body. In fact, that would be legitimizing all kinds of wrongdoing, which would rather go against the very fiber that this nation is built on. We cannot condone that.
Okay.
It is agreeable to say that we should protect all these constitutional bodies, and particularly against the executive, because the executive is overbearing. I agree. But that argument cannot supplant the position of the law when you say that a wrongdoing has been occasioned by an officer occupying any of these constitutional bodies, and because we need to protect their independence and sanctity, we should just let go of that wrongdoing. That can never be.
Okay.
So let's be focused in these discussions. Let's find out if any wrongdoings have been made by any party in this whole procedure. Let's bring it out, discuss it thoroughly, and point out the wrongs, and then recommend a possible remedies to the appropriate officers. Okay. That should be the way to go. But to be subtly making these comments as if something has been done wrong, but it is right, and then it's wrong, but it's not okay, I do not think it helps with the discussions. It doesn't help in any way.
But, I mean, Justice, we don't have time and we have to go. But in terms of whether or not something has been done wrong, when you listen to the Chief Justice in her presses and everything else she's brought to the, to the fore in terms of media, she said that her human rights are being infringed on. She doesn't know exactly what she's being accused of, which is why she's escalated the matter to, the ECOWAS courts, etc. So, I mean, I'm just hearing you say that they should expatiate exactly what has been done wrong, but we've listened to the person in question who've told us exactly what they're doing to her that is wrong, no? So we do know to an extent what will qualify as wrongdoing from her side, correct?
That is an argument you're making, but let me put it this way. If the CJ says that her human rights have been abused, what part of, how did that happen? Simply because her answer to this question is that she doesn't know what she has done wrong. But did you not witness the CJ writing to the president, ordering the president within 7 days to give her the information? Weren't you in this country?
Thank
you. And the president did so by giving her even more than the required days that she wanted.
Yeah. Unfortunately, that's our time, Justice Abdullahi. Thank you. Did
she not respond to that? No. So you cannot ask me after you have given ask this
question. Go ahead. I'll allow it. Go ahead.
So after she has been given this information, she responded to that. And that formed the basis for the Council of State's decision. Now, following from that, a committee was set up. The committee is sitting on it. So please point out which part of the accusation or human rights that has been abused, allegedly, in relation to she not knowing what she has been accused.
Well, lawyer, then from what we know, in the case of Charlotte Osei, the then Chief Justice, the name has escaped me a little, but when she provided her responses in the petition, she said Charlotte Osei was able to justify, I think it was about 2 points. The other 2 points was where Sophia Akufo, good. The other 2 points was what Charlotte Osei could not satisfactorily defend herself on, and that's what the committee was set up to then go into. 2 points. Absolutely. But this one, the CJ is saying that I don't know which of the issues and for which my responses were provided that were not satisfactory enough that I'm being taken through this process. Not fair for her to be asking those questions.
It is fair to ask, but does it amount to a breach of your human right?
Well, loss of natural justice. You should know exactly what you're being accused of so you can respond to that.
No, you have been allowed to respond to all.
Yeah.
Default position is that if you are being prosecuted for all of it, clearly means that your explanation was clearly not enough to exonerate you.
What about the emotional torture?
I don't know whether this should be an issue of quantum mathematics.
No, but isn't it fair? Isn't it fair? Isn't it fair? Isn't it fair that it is communicated to her?
Informed of which of the 5 that you are being prosecuted for, right?
Yeah.
Does it not reason that all the 5? You are standing trial for all the 5.
Okay.
Well, thank you. No, Justice, seriously, we have to have another time and get into this proper. Thank you so much. He's a senior lecturer at UPSA Faculty of Law, Justice Abdullahi. Thank you. Good sport. Right.